Your Honor, how are you?
Pretty good. Where are we starting today?
Your Honor, actually, if we could start on Judge Ward's docket with the AG case. I believe everyone is here for the Norman Barman case.
Norman Barman case.
And I believe all the parties are on Zoom for that.
All right, so we're on the record in docket 25-01426. That is people of the state of Michigan versus Norman Barman. Will the parties please introduce themselves from the record from the AG's office?
Robert Hayes, Assistant Attorney General, here for the people.
Good morning, Your Honor.
So your name is Robert Hayes? The Attorney General's office?
Yes.
All right. I didn't hear that. I didn't hear your complete name for the record.
Sorry.
Sir from the defense.
Good morning, Your Honor. Takura Nyamfukuza appearing on behalf of Mr. Barman, who is also appearing via Zoom. Mr. Barman, would you please state your name for the record?
Good morning, Norm Barman.
All right. Thank you. This is time set for a probable cause conference. Mr. Hayes, how are we proceeding?
I had an opportunity to speak with Mary Chartier this morning, and it appears that there's going to be a request to move the exam back to August.
All right. Is that a fair statement from the defense, Mr. Barman? And does Mr. Barman plan on waiving his right to a prelim within 21 days?
Yes, Your Honor.
Okay. May I inquire of Mr. Barman of his waiver of the 21-day rule?
Please.
All right. Mr. Barman, do you understand you have a right to a preliminary examination within 21 days of your date of arraignment? A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by defense counsel, the Chartier law firm, and and say your name again, sir. I'm sorry.
Takura Nyamfukuza, Your Honor.
Nyamfukuza, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Is it your wish to waive your right to a prelim within that 21-day period? You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so the Chartier law firm can zealously represent you in your defense.
Yes, Your Honor.
Okay. Mr. Hayes, does the AG also waive their right to a prelim within 21 days?
Yeah.
All right. I find the waiver, the prelim within the 21-day period to be knowing, voluntarily, and accurately made. And then let's see if we can get a date. Or have you got a date already? So this is not my case, so I'm gonna put it on Judge Ward's schedule, and then you can act accordingly from there. But it'll be placed sometime in August on Judge Ward's schedule.
August 15th.
So we set for August 15th at 8 o'clock. Is that right?
Yes.
August 15th at 8 o'clock in front of Judge Ward. There has been a waiver of the 21-day rule by defense. All right, so we've set it for August 15th at 8 o'clock in front of Judge Ward. Anything else for the record in 25-01426, Mr. Hayes?
Nothing from the people, Your Honor. Thank you.
Anything else for the record in this file, Mr. Nyamfukuza?
Nothing from the defense, Your Honor. Thank you for your time.
All right, Mr. Barman, you'll be in front of Judge Ward on August 15th at 8 o'clock. Thank you for your appearance today.
Thank you.
Thank you, Your Honor. Have a good day.
You too. That is 25-00986. That is people, State of Michigan versus Terry Smith. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Anderson.
Michael Anderson on behalf of Mr. Terry Smith. It's my understanding he's appearing via Zoom.
All right, and where's Mr. Smith?
I'm on the Galaxy S23, sir. I apologize for the camera.
You answered that. You answered that question. All right. All right. So, sir, you are Terry Allen Smith. Is that correct?
Yes, sir. Terry Allen Smith.
All right. Thank you. This is time set for a probable cause conference. Mrs. Zell, how are we proceeding, or would you like to defer to Mr. Anderson?
Your Honor, it's my understanding that Mr. Smith has been screened for sobriety court with Judge Buchanan and has been accepted into that program. I do believe today we are asking for a plea to be set with Judge Buchanan.
I think I got an email to that effect. Mr. Anderson, is that a fair statement?
That's a fair statement, Judge. I think the date was July 10th, if I'm not mistaken.
Yes.
Okay. So in order to, let's see, we want to turn for 60 days. We waived the 21-day rule on April 21st.
Oh, okay. I'm sorry.
So we will set it for July 10th. At what time?
Oh, 9:30.
All right, we'll set it for July 10th at 9:30 in front of Judge Buchanan for the plea to be taken. And then I think her rules are for her specialty court. Once she takes the plea, they adopt the case. So. All right, so Mr. Anderson, you have the date of July 10th at 9:30. Is that correct?
That's correct, Your Honor.
All right. Mr. Smith, you'll be in front of Judge Buchanan, July 10th at 9:30 with counsel. Anything else for the record in 25-00986, Mrs. Zell?
Not for the people.
Mr. Anderson.
Just for clarity and for my client, that date will be in person.
Okay. So Mr. Smith, that'll be live in person, and Mr. Anderson will be present in front of Judge Buchanan. All right, sir?
Yes, sir. Thank you, sir. And you have a nice day.
You too. You're all set. Thank you for your appearance today.
Thank you, Judge.
Thanks.
Thank you.
Where are we going next, Mrs. Zell?
I believe we can go on Tyrion Johnson, who will be appearing on Zoom as well.
That's Mr. Austin's case. Make sure it's all right, Mr. Johnson.
Seven or
All right, so we're on the record in docket 25-01766. That is people of the state of Michigan versus Tyrion Dewan Jr. Johnson. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Johnson. He appears with us remotely from the Young County Jail.
And sir, you are Tyrion Dewan Johnson, is that correct?
yes,
All right, is that pronounced correctly?
it's doing everything else is good.
I couldn't quite hear what.
I didn't quite hear what you said, sir.
My main name is Dwayne, but everything else is correct, Your Honor.
All right, thank you. This is a time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, at this time, there is no offer to be extended to defense, and we are leaving this up for the preliminary exam.
Is that a fair statement, Mr. Austin?
That is correct, Your Honor. We were just requesting as well that the matter remain on as scheduled for the preliminary hearing next week.
All right, so we'll leave on for preliminary examination on July 3rd at 8:30. Anything else for the record in docket 25011766, Mrs. L?
Not for the people.
Mr. Austin?
No, Your Honor, thank you.
All right, Mr. Johnson, we've left the preliminary examination on for next week on July 3rd, next Thursday at 8:30. You're all set. Thank you for your appearance today, sir. Who's next?
I believe we can go on Eric Hurd. If he has 2 files this morning.
All right. Do you want those called together, or did you want those? Looks like one is, they're both probable cause conferences.
I think they can be called together.
I don't have an objection to handling them that way, Your Honor. I think that'd be the most.
All right, and then Mr. Hurd is joining. All right, so we're on the record in docket 2401-836 and 2403-537. That's not right. 2401-836 and 2401-305. That is the people of the state of Michigan versus Eric Hurd. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Hurd. He appears with us remotely from the Ingham County Jail.
Thank you. And sir, you are Eric Allen Hurd, is that correct?
Yes, Your Honor.
All right. And you can hear me all right, Mr. Hurd?
Yes.
Thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, at this time, it's my understanding we are going to be leaving both of these set for their preliminary exams. At this time, there is an offer we would like to place on the record to keep it open for consideration.
All right.
That offer would be to waive up to circuit court for a global resolution of a DV third plea and a possession of meth plea with no habituals attached to it. At this time, there has been no indication other than that will be taken into consideration.
All right, Mr. Austin.
Yes, thank you, Your Honor. Those offers were conveyed to me this morning, so I obviously haven't had a chance to discuss that with Mr. Hurd, so I would like that opportunity. I don't know when we were here last. I think maybe we just set a probable cause conference, so I don't know. I think we may need to actually set an exam date, but the balance of what Mrs. L said is correct, and I would agree with that.
All right. So yes, this comes out of.
Mr. Hurd was just recently restored to competency.
Right.
We stipulated to that after the independent report came in. We set the matter for a probable cause conference, which is today. And I don't believe at that time we set it for an exam. We just set it for a conference to see how things went. And so now that there has been an offer extended, I would like an opportunity to discuss that with Mr. Hurd. So I think we could just set an exam date to allow us that opportunity. That's what I would be requesting.
All right. So we'll set the earliest possible exam date because it'd usually be next week, but I don't know how the schedule looks next week.
We can do next week.
Okay.
1 or 2 weeks would be fine.
Enough time to get out subpoenas because it's a short week.
Yeah, it is a short week because Friday's not. We could do for the following week, the 18th, or it's really, that's a really short week.
We have the 10th or 11th to 17th of the 18th. I don't know with subpoenas and all that stuff.
Good. So would that 10th or 11th date work better?
That would work better.
Certainly
for
works
us.
better than next week.
Just unfortunately, I'll have to have somebody covering that date for
All
me.
right, the 10th or 11th, which date would you prefer?
Whichever is fine.
All right,
No preference on that.
there's no preference on the 10th or 11th.
Thursday, July 10th at 1:30.
All right, July 10th at 1:30. Right, so we will set this for July 10th at 1:30 concerning the preliminary examination. Anything else for the record in either, so both files will be set for July 10th at 1:30. That's 2401-836 or 2401-305. Anything else for the record in either one of those files, Mrs. L?
Not for the people.
Mr. Austin?
No, Your Honor, thank you.
Thank you. All right, Mr. Hurd, we'll see you on that July 10th date. You should be all set. Where are we heading next, Mrs. L?
That's a great question. Anybody have anything? If you could just give us a couple moments to
Alright.
find out where and if defense attorneys are ready.
Okay,
A couple more.
yeah. And we've got 2 dockets, so just let me know.
Good morning, Your Honor. I believe we're ready on Anthony White.
That one's mine from the AG's office.
Yes, we sent in a stip and order. I want to say a
All
couple
right, is that,
discovery
all right,
request.
so that's Anthony White is that Miss Brenner? Are you here on that case?
Yes, Your Honor. Good morning.
All right, let me call that case.
Thank you, Your Honor.
Yes. We don't have a stip and order as of yet, but we'll place it on the record.
Absolutely. Thank you, Your Honor.
I don't see it either.
I can send it to emails if you guys would like. We sent it and got a confirmation from the court clerk yesterday that you guys received it, so it just must not be in the file.
All right. So most likely we have it, but it hasn't been processed yet. But we'll place it on the record. So we're on the record in docket 24022293. That is people of the state of Michigan versus Anthony White. Appearances for the record, Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Mr. Rosenthal.
Yes, good morning, Your Honor. May it please this honorable court, Matthew Rosenthal on behalf of Anthony White. Mr. White, can you please state your full name for the record, sir?
My name is Anthony White.
So your name's Anthony White?
Yes, sir.
All right, you can hear me all right, Mr. White?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. I'll indicate what I know about the case and let counsel supplement the record. It is my understanding that there has been a stipulation to adjourn the matter or request to adjourn. Is that a fair statement, Ms. Brenner?
That's what counsel's saying, Your Honor. I don't have any knowledge about a stipulation.
You haven't signed it?
I haven't seen it. I don't know if somebody else from my office has and it didn't get noted in the file, but I don't have any knowledge about it.
All right, so if Ms. Brenner hasn't signed it, I'm assuming she'd know what the rest of her office is doing. Mr. Rosenthal, we don't have a stip and order yet. Did you want to just leave this on?
I'm okay with adjourning it if Mr. Rosenthal can just outline, what his request is. I probably agree.
Mr. Rosenthal, do you have just a general outline of the motion? And is this going to require to set it outside? Will we require a waiver of the 21-day rule by your client?
Yes, Your Honor. So I can send Ms. Brenner to the stip and order that was signed by the public defender's office. We would just ask for a brief adjournment. Obviously, my client would stand mute, waive formal reading. We just need to get discovery right now. Once we can review that, Your Honor, we can look at the best way moving forward. I know he does have work lined up. We want to see, kind of what we can do working with the Attorney General's office to get him out and get him on a plan to where this can be satisfied.
All right. So Mr. Rosenthal, Did you want to leave this on for next week, or did you want us to waive the 21-day rule in regard to the stip and order?
Yes, I would ask to waive the 21-day rule, Your Honor, so I can review discovery. Once I have it, then
All
I'll
right.
go from there.
And Ms. Brenner, you have no objection to the waiver of the 21-day rule or the adjournment of the matter, so that it sounds like the public defender was involved, and then Mr. Rosenthal needs to get discovery so he can zealously represent his client.
That's fine, Your Honor. That it sounds like he worked with public defenders and not my office. So if he sends discovery, a discovery request to my office, then we can get him the discovery that he needs. I don't have any objection to waiving the 21 days or setting out the prelim so he can get what he needs.
All right. All right. So Mr. Rosenthal may inquire of Mr. White of his waiver of the 21-day rule.
Yes, Your Honor, please.
Okay. All right, Mr. White, you understand you have a right to a prelim within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Matthew Rosenthal, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish to waive your right to a prelim. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. So Mr. Rosenthal can get a discovery from the public defender's office and can zealously represent you after reviewing discovery. Is it your wish today to waive your right to a prelim within 21 days?
Yes.
Ms. Brenner, do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And we will reset. And I'm assuming, Mr. Rosenthal, that you'd want this reset in a pretty timely manner
Yes.
since your client's incarcerated.
Absolutely.
All
Your
right.
Honor.
All right.
July 10th at 8:30.
So we'll set it for July 10th at 8:30.
Is that the
All right,
prelim
so-
judge or another PCC?
Just a prelim. Is that a prelim? Yeah, it'll be just a prelim date for July 10th at 8:30. We'll let the parties negotiate. We'll set it for that date, and then we'll revisit whatever issues are on July 10th at 8:30.
Your Honor, can I?
Go ahead.
Yes, Your Honor. Can I confirm what his bond is set at to make sure it complies with the statutory requirements?
I have bond set at $47,920 cash only, according to the note left here.
Yes, that's correct. Okay, thank you, Your Honor.
All right. All right. Anything else for the record in July 10th? We've reset this for July 10th at 8:30. Anything else for the record in 24-02293? Ms. Brenner.
No, Your Honor. Thank you.
Mr. Rosenthal.
No, Your Honor, nothing else. I will make sure, Ms. Brenner, that I get you everything if it wasn't supplied, and then we'll move forward from there. Thank you, Your Honor, and thank you, Your Honorable Court. And Mr. White, please contact me when you can, sir, okay?
All right,
Okay,
you're all
thank
set,
you.
Mr. White. Thank you for your appearance today.
Thank you, Judge.
Thank you, Your Honor. Thank you, Ms. Brenner.
All right. So we're on the record in docket 2501070. That is people of the state of Michigan versus Christopher Linnell Jackson. Will the parties please announce their appearance for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office, filling in for Jeff Kaplan and representing Mr. Jackson, who is standing to my right.
And sir, you are Christopher Jackson, is that correct?
Sam, Your Honor.
Thank you. All right, this is the time set for sentencing in the matter. And Mrs. L, is there any restitution on this matter?
Your Honor, I don't believe that there is any
I
restitution.
don't see any.
We do not have any information about restitution.
All right, Mr. Goodrich, did you have the opportunity to go through the pre-sentence report with your clients?
Yes, we did, Your Honor.
Any additions, deletions, or corrections?
The one correction we had was under employment data. It should show that he is employed full-time at Cooper's Hawk, but he earns $1,000 bi-weekly.
I'll make that correction. All right, any other additions, deletions, or corrections, Mr. Goodrich?
No, Your Honor.
All right, allocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, prior to this matter, Mr. Jackson had never been convicted of any type of domestic assault in the past. He certainly regrets the incident that took place on that occasion. He has, I know there was some incident regarding a dog which brought about that violation. However, since that time, there hasn't been any contact. He's got a job now working at Cooper's Hawk as a line cook. He's working at potentially getting a different or another job with a friend who might be opening up a bar soon. We would ask the court to allow him to work in places that sell alcohol, but obviously not be there when he was off work. One thing that was in the report was that he missed his pre-sentence investigation meeting the first time, but that was due to getting arrested for that bond violation. Then he took the initiative to reschedule it and get it done in time. Your Honor, I think shows that he's committed to following the court's orders, and I think he would benefit from the type of domestic violence class as recommended here. I'm certainly willing to do a drug alcohol assessment to see if there's any further issues there. But we were just essentially asked the court to sentence him to a term of probation with the 769.4A status to give him the opportunity to earn that non-public record. Your Honor. Thank you.
Thank you. Mrs. L, would you like to be heard on the record concerning the sentencing of Mr. Jackson?
No, Your Honor, we leave this to your discretion. Thank you.
Thank you. Mr. Jackson, is there anything you'd like to say to the court before the court passes the sentence?
Just that I'm sorry for the actions that happened that day, and I promise to think about things before I act on it.
All right. Thank you. I'm in line with the plea agreement here and the pre-sentence report. So this is for a guilty plea. I should say a no contest plea of April 24th, 2025. One of the reasons for the no contest plea would be the lack of memory from the event. And that's why there's some of this drug and alcohol as ordered because of the amount of or because of the alcohol intake at the time. So it is ordered that the defendant spend 45 days in jail, get credits given for 2 days previously served. I'll suspend the remaining 43 days upon successful completion of probation. So there'll be no upfront jail. There'll be fines and costs of $250, costs of $250, crime victims' rights fee of $75, state minimum cost fee of $50, and a probation. I'm placing on probation for 12 months. So that'll be $500, $625 plus $360, $985, and that can be paid over the course of probation. So probation for 12 months via Zoom. The 769-4A is granted. That's really the carrot here, okay? Because if you complete probation, this is abstracted in a different way. No contact with the victim, Amanda Burtz, would be within 2,000 feet of where the victim lives, works, goes to school without the consent of this court. So even if Ms. Verts indicates to you, you can have contact, you can't have contact. Another, the only thing that works is another order from this court.
Yes.
No assaultive threatening behavior, no use of possession of alcohol, marijuana, controlled substance, submit to random PBTs, enter urinalysis as directed and pay fees. No bars or nightclubs unless you're working, okay? So unless, since I know that some of the establishments have a bar area and a restaurant area, you can certainly work there. It creates all kinds of problems for if you have a tendency to want to partake. So this is your opportunity to show off a little bit, okay? So unless working, complete following rehabilitative services, pay fees, and provide proof of completion to the court. I don't know what's BIS. Okay, so the domestic violence probation court, you should take that program. Alcohol drug use educational course, you should take that program. Those are all can be taken over the course of probation. Obtain and maintain employment, you've already started on that. And not purchase or possess firearms, ammunitions, or weapons of any kind. Your probation agent is Jody Bayless. So I would go down to the 5th floor, check with the probation department, make sure you're online for everything. Mr. Jackson, how this works is if we see less of each other, that's probably the better thing, right? Because that means you're not being violated. And then we can start this relationship of making sure that you're doing what you're supposed to do. So we can treat this as a one-time thing, all right? If we see more of each other, that means you're violated. And what people usually come in front of me for is they drop dirty, okay? They drop dirty, and then we're seeing if the programming is working. Ultimately, it's supposed to be harder to get drugs and alcohol in jail, so that's why I have that term. I don't want to use that, and as you know, I'm more interested in making sure, Mr. Jackson, I'm not concerned about you in the next 12 months because you're on probation to me. And if you're dropping dirty, then I know where to put you where it's harder to get alcohol and drugs. I'm more concerned about Mr. Jackson 2 or 3 years from now when there's no oversight and you've got to make good decisions, right? All right. With that understanding, I will sign the JOS. We probably should make it pretty. Yeah. We probably should make it look pretty so nobody yells at me. And 627. I can't read my writing. And you should be all set, sir. Thank you for your appearance.
Yes. Yes.
Thank you.
We have a Charles Snyder on Zoom.
Yes, we do.
We do his PCC.
All right.
Leave that there, so.
Let's do Mr. Snyder. That is a Judge Ward case. That's the last case. All right, Mr. Snyder, we'll call your case on Judge Ward's docket. We're on the record in docket 25-01817. That is People of the State of Michigan versus Charles Snyder. Appearances for the record. I'm going to mispronounce your name, so go ahead. Say
Good morning, Your Honor. Maluda Buxia, Assistant Ingham County Prosecutor, on behalf of the people.
Buxia. All right. Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Snyder, who is appearing over Zoom.
And sir, you are, and you can unmute Charles Snyder. You'll have to unmute. Mr. Snyder.
Can you hear me now,
Right.
sir?
Yes, I can. So, sir, you are Charles Snyder, is that correct?
Your Honor.
Is that a yes?
Hello.
Mr. Snyder, can you hear
Can you
me?
hear me now?
I can hear you fine. Can you hear me?
Hello.
That would be a no. So, Mr. Snyder, you can't hear me. I can hear
Yes.
you.
Can you hear me?
Yes, I can hear you.
Okay, I can hear you now.
All right. Sir, you are Charles Snyder, is that correct?
Yes, sir.
All right, thank you. This is a time set for a probable cause conference. Mr. Buxi, how are we proceeding?
Thank you, Your Honor. It is my understanding that the defense wishes to leave this matter set for the preliminary examination. However, I believe defense is going to be asking for a waiver of the 21-day rule due to a scheduling conflict.
Is that a fair statement, Mr. Goodrich?
Yes, Your Honor. Just that conflict being that I'm going to be out of town next Thursday.
All right. And Mr. Snyder is willing to waive his right to a prelim within 21 days. Is that correct?
That is correct, Your Honor.
May I inquire of Mr. Snyder of his waiver of the 21-day rule?
Yes, Your Honor.
Mr. Snyder, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Luke Goodrich, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period for conflict purposes. Is it your wish today to waive your right to a prelim within 21 days?
Yes, Your Honor.
Mr. Buxi, does people also waive their right to a prelim within 21 days?
Yes, Your Honor.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset. So we're looking for time frame sometime outside of that.
Yes.
Judge Moore's next available is August 15th.
Okay, August. So just looking at Judge Ward's calendar, it's August 15th at 9 o'clock for the prelim. All right, so Mr. Snyder, please keep in contact with your attorney, Mr. Goodrich. We've reset this for August 15th at 9 o'clock. Anything else for the record in 2501817, Mr. Buxi?
Not from the people, thank you.
Mr. Goodrich?
No, Your Honor, thank you.
All right, Mr. Snyder, you're all set. Thank you for your appearance today.
Thank you.
And sir, you are Jeremy Rayler, is that correct?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Rayler?
Yes, sir.
All right. This is a time set for a probable cause conference. For the record, Mrs. L, what are we doing here today?
Your Honor, it's my understanding that today there will be a no contest plea to the offer that has been extended, which is to plead to an added count 3 of domestic violence under 750.812, which is a 93-day misdemeanor and or a $500 fine. Upon proper plea and sentence, the count 1 and count 2, the habitual offender, would be dismissed.
And this is a no contest plea.
Correct.
Is that correct? And so that'd be make sure, that'd be I only have one count.
It would be an added count 2. Your Honor.
Oh, added count 2. Okay. All right. And what is the reason for the no contest plea?
Lack of memory due to intoxication.
And is that a correct statement, Ms. Robinson?
Yes.
All right. So really for my edification purposes, there's going to be a no contest plea to count 2. That's under 750.812. With a plea, count 1 is to be dismissed. This is no contest plea and purposes or lack of memory due to intoxication. Is that your understanding, Ms. Robinson?
It is.
All right. May I inquire of your client of their misdemeanor advisory rights?
You may.
All right. Mr. Rayler, you have the following jury trial rights in this no contest plea. And I'm going to walk you through those. Okay, sir?
Okay.
All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty. You have witnesses against you appear at trial. To question any witnesses are brought against you. To have the court order any witnesses appear in your defense. To remain silent during the trial. Not to have that silence used against you. And to testify at trial if you choose to testify. You are represented today by Attorney Erin Robinson. And she would be present to cross-examine any witnesses or contest any charges brought against you by the people at trial. Do you understand that, sir?
Yes, sir.
If your no contest plea is accepted, you'll give up the claim the no contest plea was a result of any promises other than what we put on the record or threats that it was not your choice to plead guilty. You're also giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading no contest instead. Is it still your wish to plead no contest to the misdemeanor count of domestic violence?
Yes, sir.
All right. So for the factual basis, my understanding is I'll be using case number 255-190-2241. That's the LPD or the Lansing Police Department report that was provided. Is that correct, Ms. Robinson?
It is.
Mrs. L.
That's correct, Your Honor.
All right. I will indicate that the report states that this occurred on March 8th. At 1215 East Michigan Avenue in the city of Lansing. That Tracy Marie Rayler and the defendant Jeremy Eugene Rayler were married. Tracy Marie Rayler indicated that the defendant was intoxicated, that she had been scratched by the defendant on her cheek and chest. She explained that when she first met the accused, things were good, but once they got married, he began to become extremely abusive. He went to prison for that. On the day of the incident, she believes he was so intoxicated, he has no memory of the event. There's an indication that she says that he grabbed her by the neck and scratched her face, which would confirm the offensive touching of another. Anything towards the no contest factual basis, Mrs. L.
No, Your Honor.
Ms. Robinson.
No, Your Honor, thank you.
Yeah, I find the factual basis to be knowing, voluntarily, and accurately made concerning the no contest plea. Will refer to probation. And we'll set for sentencing
August 28th.
August 28th at 9:30. So, Mr. Rayler, if you're not incarcerated, you should go to the 5th floor of City Hall to see probation officer. If you are incarcerated, probation will be out to see you concerning the sentencing date of August 28th at 9:30. All right, sir?
Okay.
All right. Anything else for the record in docket 25-01154, Mrs. L?
Not for the people.
Ms. Robinson.
Yes, Your Honor, we'd like to ask for a reduction in bond at this time. Right now, the bond is too high for Mr. Railer to post. He does report that he is currently working. He does have a job at Little Caesars and was attending drug treatment where he could go back to and continue his treatment.
Thank you. Mrs. L, anything on bond?
Your Honor, since a plea was entered today to a misdemeanor down from a felony, we understand the motion for the bond request. We would also ask that potentially that drug treatment be worked into the new bond requirements if possible. Otherwise, we leave it to the court's discretion. Thank you.
Thank you. I have that this was charged as a 3rd offense notice with 2 priors, and then a 4th offense notice, habitual 4th, with a prior CCW, a prior flee and elude. This comes down from a felony. I'll set bond, reduce bond to $8,000, 10% for the plea to the misdemeanor. Anything else for the record in docket 25-01154, Mrs. L?
Not for the people.
Miss Robinson.
No, Your Honor, thank you.
All right, you should be all set, Mr. Rayler. Thank you for your offense, for your appearance today. And I will return the no contest police report to the defense.
No, yeah.
What was that? I was trying.
Really?
Not for the TV, Your Honor. Ms. Robbins.
No, Your Honor, thank you.
We're all set. Thank you for your appearance today. Then Ms. Robinson, while you have you here, did you want to do Curtis?
Read my mind.
I think I heard something.
Ms. Curtis, you can come on.
We're just happy to have you here before you take off. All right.
Thank you.
On to other courts. All right, so we are on the record in docket 25-01305. That is people of the state of Michigan versus Maury Curtis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Ms. Curtis.
And ma'am, you are Marie Curtis, is that correct?
No, Maury.
Maury Curtis, thank you. This is a time set for a probable cause conference. And Mrs. L, how we proceed?
Your Honor, it's my understanding we are going to be leaving this set for a preliminary exam.
Right. And is that a fair statement, Ms. Robinson?
It is.
So we'll leave on for prelim for July 3rd at
I don't think it was scheduled for an exam because there was a
PCC.
previous waiver. So we're gonna need an exam date.
Yeah,
I'm sorry.
yeah, there's,
My apologies. 2 weeks.
Sure. As long as it's not the 10th through the 14th.
That is 2 weeks.
Okay, that's, okay, I'm out the 10th through the 14th.
Okay,
Sorry.
you're okay.
we have a previously 21-day rule waiver
Yes.
on May 16th.
1:30 on July 18th.
That works perfect. Thank you.
July 18th at 1:30. All right, so we'll leave on for preliminary examination for July 18th at 1:30. Anything else for the record in 25-01305, Mrs. L?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right.
Excuse me, can I say something?
Sure, Ms.
Not if
Curtis.
it's about the facts of the case, okay?
You can say something about the process. You shouldn't say anything about the facts of the case.
Well, she only gave me 2 options, so I really don't understand.
I'm only, okay, so you have 2 options. You can talk about the process, the date that we've set it for, but you shouldn't say anything about the facts of your case.
No, I wanted to plead guilty.
Right, that sounds like you should talk to Ms. Robinson about that.
Well,
So I'll let you talk to Ms. Robinson. We've set it for July 18th at 1:30. Thank you for your appearance today, ma'am.
already on the elevator by now. So. Sorry, you only drive so fast.
All right,
Going over to Judge Ward's docket, Your Honor.
okay, thank you.
With Olivia Reeves and Adam Slamma.
Both Mr. Austin. So let's go on Reeves first. And then Slamma. All right, so we're on the record in docket 25-01775. That is People of the State of Michigan versus Olivia Reeves. Will the parties please introduce themselves for the record? Mr. Boogsy, and I don't know if I'm pronouncing it.
Thank you, Your Honor. Maluta Buxia, Assistant Ingham County Prosecutor on behalf of the people.
All right. Mr. Austin.
Morning, Your Honor. Jared Austin appearing on behalf of and in the absence of Olivia Reeves.
All right, thank you. This is a time set for a probable cause conference concerning Olivia Reeves. As previously indicated, I would think that this is also that we're not sure where Ms. Reeves is. She could be in another Zoom courtroom. So Mr. Boogsy, how we proceed?
Your Honor, I have had the opportunity to speak this over with Mr. Austin. We did make an offer. If Ms. Reeves was to waive her preliminary examination, she would be preserving an offer of a home invasion second degree. Mr. Austin and I had briefly talked about leaving the PE set, but without witnesses. I'm not sure how the court would like to move forward, whether with or without witnesses. I would leave it to your discretion. Maybe Mr. Austin would be able to.
Mr. Austin, can you any supplemental on behalf of Mr. Reeves, Ms. Reeves, on the record?
Yes, Your Honor. I have not been able to make contact with Ms. Reeves. We do not have an email address. We do have a phone number that was provided. It doesn't appear to be a working phone number. We have sent a letter to the physical mailing address we have on file that hasn't either been returned to us as of yet or generated any type of response. Doesn't appear that Ms. Reeves is in custody. However, this is also a Judge Ward matter. I was not aware until this morning that Your Honor would be covering Judge Ward's docket. So it's quite possible that Ms. Reeves is currently in Judge Ward's Zoom court and we wouldn't be able to tell. So
I'm reluctant to bench warrant anybody because we don't know where they are. We don't even know if it's being monitored right now. So just leave it on.
What I would request, Your Honor, is to, yes, leave the exam date on to see if Ms. Reeves appears. Given that I haven't had contact with her as of yet, I would have no objection to the people being able to call off witnesses so that they're not unnecessarily inconvenienced. But I would request that no action be taken against Ms. Reeves at this point.
All right. And I think that's a fair request to leave on, but to have no witnesses here for next week since we don't know the status of the case.
Yes, thank you, Your Honor. The people are not requesting a bench warrant due to obviously the circumstances given today. We do appreciate not having to bring in witnesses, however, for this preliminary exam.
All right, perfect. So we'll leave on for July 3rd at 9:30, and I'll leave counsel to handle the case at that point in time. No witnesses are necessary for that preliminary examination per the request of both counsel, since we don't know what's happening at that time. All right, anything else for the record in 25-01775? Mr. Boogsy.
No, thank you, Your
Honor. Mr. Austin.
Nothing additional on behalf of Ms. Reeves, Your Honor.
All right, so that's on Ms. Reeves. And then we can go on Mr. Slamma. All right, so we're on the record in docket 25-01747. That is People of the State of Michigan versus Adam Slamma. Appearances for the record, Mr. Boogsy.
Thank you, Your Honor. Maluta Buxia, Assistant Ingham County Prosecutor on behalf of the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Slamma.
Okay, this is the time set for a probable cause conference. Mr. Boogsy, how are we proceeding? And do we have a similar is this a similar case?
It is a similar situation, Your Honor. However, the difference here is that Mr. Austin has had opportunity to speak with his client. And from what I understand, the preliminary examination with witnesses is going to be what was requested with his presence here anyways. So we do feel more comfortable moving forward with a preliminary examination and bringing in witnesses on this case, Your Honor.
All right, so, and is that a fair statement, Mr. Austin?
Yes, it is, Your Honor. Again, this is a similar situation. I wasn't aware that Judge Ward's docket would be being covered by Your Honor this morning. I did send an email to Mr. Slama stating as such. Once I learned of that, I don't know if he has received it, but I have had no less than 3 phone conversations with Mr. Slama. We've also communicated via email. He reports to me that he's reported to pretrial services. My understanding, he was planning on attending this morning via Zoom with Judge Ward. So given that, Your Honor, that I've had good contact with him, I would ask that the matter remain on as scheduled for the preliminary hearing with witnesses.
All right, so we'll set this. All right, so we'll set this for July 3rd at 8:30. Leave the prelim on with witnesses. Anything else for the record in 2501747, Mr. Booksy?
No, thank you, Your Honor.
Mr. Austin?
Nothing additional, Your Honor. Thank you.
Yeah, just to confirm, number 1 on Judge Ward's docket, Elon Adderley, that was taken off, right?
Yeah. Yes.
Okay, thank you.
Submit the post. On the iPhone, could you please identify yourself on the iPhone 2? Say your name again, sir. You broke up a little bit.
Trinity Smith on Judge Ward's docket with Ms. Lundy.
So Atrinius Smith, is that correct?
Sure.
All right, and you're here for your 8:30 in front of with Miss Wanji as your attorney, is that correct?
Yes, sir.
All right.
I'm here.
All right, Mr. Booksy, is that your case?
That was mine.
Oh, that's Ms. Kachukas. All right. All right, let's see. All right, Ms. Kachukas, are you ready to go on Mr. Smith's case?
Yes, Your Honor.
All right, so we're on the record in docket 2501771. That is people of the state of Michigan versus Atrinius Smith. Appearances for the record, Ms. Kachukas.
Good morning, Your Honor. Cassidy Kachukas for the people, appearing on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Biwanji for Mr. Smith, who's appearing by Zoom.
And sir, you are Atrinius Smith, is that correct?
Yes, sir.
And you can hear me all right, Mr. Smith?
Yes.
All right, thank you. This is the time set for a probable cause conference. Ms. Kachukas, how are we proceeding?
Your Honor, there is no offer extended in this case, so I will defer to Ms. Wanji as to how to proceed today.
All right, Ms. Wanji.
Your Honor, we're just going to leave it on for next week.
Okay, so we'll leave on for preliminary examination for July 3rd at 9 a.m. So we're leaving on for July 3rd at 9 a.m. in front of Judge Ward. Anything else on the record in docket 2501771? That'll be live in person in front of Judge Ward for that preliminary examination. Ms. Kachukas.
Not from the people, Your Honor.
Ms. Wanji.
Not for the defense, Your Honor. Thank you.
All right, Mr. Smith, we'll see you live in person on the 6th floor of City Hall next week. Thank you for your appearance today.
All right, thank you.
And then Ms. Wanji, we're here on, did you want to call Davis?
People already on Davis, Your Honor. Ms. Wanji is.
All right, Ms. Wanji, we can call Davis.
That's fine. No, thank you.
All right. What's that? Okay. All right, so we're on the record in docket 2402142. That is people of the state of Michigan versus Gerald Davis. Appearances for the record, Ms. Kachukas.
Good morning, Your Honor. Cassidy Kachukas for the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Albiwanji for Mr. Davis.
And this is a probable cause conference. And are we just leaving this on?
That's what I would assume, Your Honor.
All right. Ms. Wanji, we're waiving the appearance of Mr. Davis because we don't know. That's a similar aspect?
Yeah, I did to him. He's been on Judge Ward meeting room since 8:30. So I talked to him and gave him the number, the meeting ID for your room, but I don't see him. But we were going to leave it on for next week anyway, Your Honor.
All right. My understanding is that is that Mr. Davis? Yes. Mr. Davis, you can come up here. Ms. Wanji, Mr. Davis is here.
Okay.
So we'll just go ahead and put it on the record.
That's
Sir,
fine.
you are Gerald Davis, is that correct?
Yes, yeah.
All right, thank you. This time set for a probable cause conference. It's my understanding Mr. Davis was in a separate Zoom courtroom. He's now here. And the probable cause conference, we're just leaving it on for prelim for next week. Is that correct, Ms. Kachukas?
Yes, Your Honor, that is correct.
And that's your understanding, Ms. Wanji?
Yes, Your Honor, it is my understanding. Thank you.
All right. So we'll set for prelim in front of Judge Ward on July 3rd at 10 a.m. All right, so Mr. Davis, this is being left on for prelim on July 3rd at 10 a.m. in front of Judge Ward. That'll be live in person on the 6th floor, and she's right across. You know where she is. She's right across right across from the elevator. Anything else for the record in 2402-142, Ms. Kachukas?
Just briefly, Your Honor, the offer in this matter is that Mr. Davis may plead to 1 count of PIP and the misdemeanor safe storage violation. And in exchange, we will not add the habitual offender notice that should have been added initially, and we will dismiss the felony firearm. And that would be obviously a circuit court plea.
All right, so the offer's been placed on the record. Ms. Wanji, you'll be able to talk to Mr. Davis about the offer that's been made. Anything else for the record in 2402-142, Ms. Kachukas?
Not from the people.
Ms. Wanji.
Nothing for the defense, Your Honor. Thank you.
Thank you. All right, Mr. Davis, you're all set. It'll be live on the 6th floor. Thank you for your appearance today on July 3rd at 10.
Okay, thank you.
Your Honor, while we have Ms. Wanji, would she potentially be ready on the sentencing for Dean Brooks Hudson?
Yes, coming.
So it's Brooks Hudson.
Yes.
So Ms. Wanji, you're ready to go on Brooks Hudson.
I am.
Is Brooks Hudson here? All right.
He is.
All right, thank you. And he's right here. All right, so we're on the record in docket 25-01033. That is people of the state of Michigan versus James Dean Brooks Hudson. Would the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Albiwanji, appearing for Mr. Brooks Hudson.
And sir, you can correct my pronunciation. Are you Jamie Dean Brooks Hudson?
Yes, sir.
Okay, thank you. This is the time set for a sentencing in the matter. And Mrs. L, do you have any restitution in this matter?
No, Your Honor, there is no restitution.
All right. Ms. Wanji, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, I have. We don't have any corrections or deletions.
Okay. All right, allocution, Ms. Wanji.
Thank you, Your Honor. Your Honor, I did review the PSI with my client. One thing that I will say is that this is the first charge that my client has as an adult. And I understand that there is a recommendation, although I'm confused with that, there is a recommendation that he avail himself to the moral recognition therapy. I don't know what is going to be serving at this time. So I will ask the court not to order him to do that. I do believe that Mr. Brooks Hodgson is employed. He has a good job. I don't think that alcohol is an issue in this case, or any other illegal substance. Mr. Brooks Hodgson does have a medical card for marijuana, and if the court was to put him on probation, we would respectfully ask that the court allow him to use his medical card. I also believe that the 8 months probation is kind of excessive. I would ask the court if the court wants to do some probation to give a lower amount of time of probation. I guess I would have just request that the court sentence him to fines and costs, because I really don't know what the probation is going to be serving at this time. Thank you.
Thank you. Mrs. L, any comment on the sentencing for Mr. Brooks Hudson?
Yes, Your Honor. We would ask for a term of probation. We would disagree with defense counsel. It does seem that alcohol was involved in this incident, including at the bottom of the PSI report, where the defendant does make a statement and says that he was drinking before this incident. Additionally, Your Honor, there was quite a bit of violence involved in this underlying incident. Police officers had to break down a door to get to somebody who was screaming for their help. Your Honor, I understand that this was led to an attempt R&O at this time, but we do think that a term of probation will serve the defendant well. Having him do some testing for alcohol consumption does seem like a good idea at this time, and potentially no bars or nightclubs, as alcohol seems to be something that can cause some aggression here. At this time, Your Honor, we would ask that the recommendation be followed, but that a term of probation is applied here. Thank you.
Thank you.
If I may, regarding the domestic violence, allegation of domestic violence, I do believe that the prosecutor knows that the alleged victim did call them and said that what she told the police was not correct, and that she lied. So I don't know. She was drunk, and she was so drunk that she was asking for help. So I still believe that probation is not needed at this time, and that what I will stick to that, Your Honor. Thank you.
Thank you, Mrs. L.
Thank you. And yes, defense counsel is correct. We did receive a phone call where the victim, and I quote, said, "I recant. I am not sending my children's father to jail. The police report is wrong. There was no weapon. I hit him first. He hit me in self-defense." I would state that that is an inconsistent statement that defense is correct about. However, Your Honor, he did plead to an attempt resisting and obstructing, which did indicate also violence against the police. And had we gone into an exam on even just that resisting and obstructing, body cam footage would have shown the aggression in that towards officers, Your Honor. Even if we ignore the underlying DV accusations, there was still aggression here, and alcohol was still involved.
Thank you. Mr. Brooks Hudson, is there anything you'd like to say to the court before the court passes sentence?
Nope, no, sir.
All right, thank you. Well, this is for a guilty plea on April 25th, 2025 to the attempt R&O. There's a Killebrew agreement of no upfront jail. I'm going to follow that Killebrew agreement at this time. So the defendant is to spend 180 days in jail. Credits given for 1 day previously served. I'll suspend 179 days upon successful completion of probation. Mr. Brooks Hudson, alcohol was a huge factor here. I know what your counsel's saying, but it is my reading of the report and then the pre-sentence probation report that they're recommending this for a reason. It's your chance to show off, okay? It's your chance to show us that there's no alcohol, it's not a problem. But if it is a problem, we need to know it, and then we have to act accordingly, and we need to set the right, we have to set the right plan, okay? that's the whole purpose of district court. Whole purpose of district court is to make sure you're making good decisions. Some decisions weren't made very well on this date, for whatever reason, so I'm going to set fines and costs. So fines at $250, costs at $250, crime victims' rights fee of $50, state minimum court cost fee of $50, and probation at $240 at $30 a month for a grand total of 5,740, 865. That can be played over the course of probation. Probation is set for 8 months at $30 a month. I'm following the Killebrew agreement of no upfront jail. I find that that there should be no assaultive or threatening behavior per the request by probation. No use of possession of alcohol, marijuana, or controlled substance without a prescription, since you're indicating you do have a medical marijuana card. If you provide that and show that to your probation agent, I'm going to check the box that says allowing that for prescriptive purposes. So that's allowed with the identification of the card. Submit to random PBTs, enter your analysis as directed, and pay fees. Mr. Brooks Hudson, that's usually what trip people up. They drop dirty, they come in front of me, and then we start this process. All right, just so you know that. No bars or nightclubs. I'm going to have you attend the cognitive behavioral therapy CBT class. Following rehabilitative service, pay fees and provide proof of completion to the court. One of the main aspects of that class, my understanding, is to make good decisions. All right, the problem between anger management, alcohol, and this may be the perfect storm for making decisions that don't help you. Okay, not purchase or possess firearms, ammunitions, or weapons of any kind. I don't think we need to pretty this one up. 6/27, 2025. So I would contact your probation officer, who wrote the report is Nathaniel Neves. So I would just find out exactly what Mr. Neves wants per Zoom for your probation, and you should be all set. All right. All right. Anything else for the record? In 2501033, Mrs. L.
Not for the people.
All right. Any questions of me, Mr. Hudson? You should be all set. Thank you. Ms. Wanji, you're all set. Thank you for your appearance today.
Your Honor, can we do Nicholson? It's also Judge Ward's case. And like,
yes. All right. Let's see. That was on Brooks Hudson. All right. And then Mr. Brooks here, are you ready on? Yeah, we've got plenty to go on, Ms. Wanchi. Let's just figure out the order we're calling them in.
Johnson, we're just gonna leave it on. He's in custody. He's on the screen. We're just gonna leave it on the screen.
Okay.
So, but that's Malou, right?
Yes.
Devil
Yep.
Johnson?
Yep.
Yeah, we're just gonna leave it on. She's got discovery. We're in.
All right, so is that the second? Jackson. That would be the problem. All right, so do you want to call Mr. Jackson?
We can call Mr. Jackson. Yeah.
Come on.
Let's get him out of the room. Yeah.
All right. All right, so this is Judge Ward's case, and this is Mr. Jackson. So we're on the record in docket 2501795. That is people of the state of Michigan versus DeVell Jackson. Will the parties please introduce themselves for the record? Mr. Buxia.
Thank you, Your Honor. Malou Buxia, Assistant Ingham County Prosecutor on behalf of the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, Fourth Assistant Public Defender, appearing on behalf of Mr. Jackson. I'm here present in person. Mr. Jackson is appearing by Polycom from the Ingham County Jail this morning.
All right, thank you. And sir, you are DeVell Jackson, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Jackson?
Yes, sir.
All right, this is the time set for a probable cause conference. Mr. Buxia, how are we proceeding today?
Thank you, Your Honor. This is a case that will be handled by Adam Pfeiffer of our office. We, however, today wish to have the matter set and kept on essentially for preliminary examination. I believe the court has already given a date.
All right, and that's a fair statement, Mr. Sartz.
That's correct, Your Honor. Mr. Jackson requests his preliminary examination as it is currently scheduled. We have discovery. We will be ready to proceed on July 3rd. Thank you.
All right, we're leaving this on in front of Judge Ward for July 3rd at 10:30. That would be July 3rd, next Thursday at 10:30. That'll be live in person on the 6th floor of City Hall. Anything else for the record in 25-01795? Mr. Buxia.
Nothing from the people. Thank you.
Mr. Sartz.
No, Your Honor. Thank you.
All right, Mr. Jackson, Judge Ward will see you next week.
Thank you. Your Honor, sticking with Judge Ward's docket and Mr. Sartz, we are also ready to go on Franklin Dumont, Your Honor.
All right, so we're on the record in docket 25-01797. That is people of the state of Michigan versus Franklin Dumont. Will the parties please introduce themselves for the record? Mr. Buxia.
Thank you, Your Honor. Maluda Buxia, Assistant Ingham County Prosecutor on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, 4th Assistant Public Defender, here on behalf of Mr. Dumont. Mr. Dumont is present at council table. He is standing to my right.
And sir, you are Franklin Earl Dumont, is that correct?
Yes, Your Honor.
Thank you. This is a time set for a probable cause conference. Mr. Buxia, how we proceed?
Thank you, Your Honor. At this time, the people have made an offer whereby if Mr. Dumont was to waive his preliminary examination, he would be reserving an offer of possession of methamphetamines, but dismissing the habitual fourth offender status. At this time, I believe Mr. Dumont wishes to waive his preliminary examination to have this offer preserved until at least the first pretrial conference in circuit court.
Is that a fair statement, Mr. Sartz?
Yes, Your Honor. This is going to be unconditional waiver of his preliminary examination. Thank you.
And it's your understanding this is open until the first circuit court pretrial?
Negotiations will continue up in circuit court, but that's correct, Your Honor. Thank you.
May I inquire of Mr. Dumont of his waiver of the preliminary examination?
Yes, please, Your Honor.
All right. Mr. Dumont, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Jacob Sartz. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are continuing between parties. There has been an offer placed on the record and it is open until circuit court first pretrial, but negotiations between Mr. Sartz and the people are continuing. Is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
Mr. Buxia, do the people waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation. I'm in possession of bind over documentation concerning 25-01797. I'll indicate the examination has been waived on June 27th, 2025. Bond is set in this matter at 10,010%. Signed by all the parties. Anything else come to the attention before the court signs the bind over documentation, Mr. Buxia?
No, thank you, Your Honor.
Mr. Sartz.
No, Your Honor. Thank you.
I will sign the bind over documentation. So, Mr. Dumont, your time in district court on this file is now done. You're off to circuit court. Will you get your next date to appear from your attorney, Mr. Sartz. All right, sir?
Yeah.
All right. Anything else for the record in 25-01-797, Mr. Buxia?
No, thank you, Your Honor.
Mr. Sartz?
No, thank you, Your Honor.
You're all set. Thank you. All right, so let's take a break and we'll let you line up and we'll give everybody we'll give myself, I should say, and everybody a chance just to walk around and we'll be back about 10:30.
All rise.
Motion at 11.
I leave.
All right, Mr. Slama, you're here on your PCC in front of Judge Ward, I believe. Mr. Slama?
Yes, hang on one second.
Mr. Slama, your case, you should contact the attorney in your case. It's been left on for prelim for next week in front of Judge Ward, all right?
I sent him an email. I just now corresponded with him.
All right, perfect. All right, so contact Mr. Austin, but that's been left on for next week.
Okay, thank you.
Thank you, sir. All right, Mrs. Zell, where are we heading?
I believe we're ready on Matthew Christie, if we want to call that one.
Matthew Christie. All right, so we're on the record in docket 25-01838. That is People of the State of Michigan versus Matthew Christie. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Matthew Christie.
All right, and is Mr. Christie joining us today?
I believe that Mr. Christie is joining us from the Ingham County Jail here at Polycom.
All right, and sir, you are Matthew Christie, is that correct?
Yes.
And you can hear me all right, Mr. Christie?
Yes.
Thank you. This is a time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, at this time, it's my understanding we're going to be leaving the set for the preliminary exam.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll leave on for preliminary examination for July 3rd at 8:30. So we'll leave it on for July 3rd next week at 8:30. Anything else for the record? That's one of that. So that'll be in this courtroom on the 6th floor of City Hall of Lansing. That'll be live. Anything else for the record in 2501-838? Mrs. L.
Not for the people.
Mr. Lee.
Nothing further. Thank you.
All right. Mr. Christie, we'll see you next week at this time. Thank you for your appearance today.
Yeah.
Oh, who's next, Mrs. L?
I think you have to, actually, we probably call Roy Lewis real quick.
That is a competency case with Mr. Phillips. All right. Miss Iselle, did you want, we have two different files. Did you want them called together or separately?
If we could call them both together, I
All
think
right.
we can do that.
All right, so we're on the record in docket 24-03240 and 25-00159. That is People of the State of Michigan versus Roy Lewis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Roy Lewis. Mr. Lewis is not present at this time.
All right. This is the time set for a competency review hearing. We previously saw, this was previously, looks like it was set on June 23rd.
This is the.
What's that?
We have the.
All right. So it was set on June 23rd. Mrs. L, how are we proceeding?
Your Honor, at this time, we do have a report that does indicate competency. It was our plan today to stipulate to that report. However, with Mr. Lewis not being here, we do not believe we would be able to move forward in that way today. At this time, it does seem like a bench warrant may need to be required. Last time we did go for a 48-hour bench warrant. I would be inclined to ask again for that 48-hour hold to give defense counsel an opportunity to try to speak to Mr. Lewis. But I will leave that to the court's discretion.
All right, Mr. Milks.
Thank you, Your Honor. Counsel is absolutely correct in this matter, Your Honor. We would be stipulating to the report itself. Did have the opportunity to speak with the doctor in this matter. We, as the court may recall, and which was already stated by Mrs. L, that we did run into this problem last time, Your Honor. My client's, he's older, attempts to contact him have gone straight to voicemail. It's a relatively quick turnaround with 5-day requirements. It would be a matter of grace if the court would allow us the 48 hours. Very honestly, I don't know, based upon last time, I don't know if we'll be able to contact him in time, Your Honor, but again, given any opportunity to do that, Your Honor, we greatly appreciate it.
All right, thank you. So this was a competency review where the defendant was to go there and get reviewed and then come back, or was he to be seen by them and then was, but if he's out, he's already there. He's going there to get reviewed or going to a place to get reviewed.
He has already been reviewed, Your Honor. He was remanded for that review and then was released once that review was done. So we do have that completed report. We simply just don't have Mr. Lewis here today.
And Mr. Milks, have you had any contact with Mr. Lewis?
No, I've not had any contact despite attempts.
All right. I have some, this is, I know some failed to appears here were based that we were involved in the finding forensic, but before it ever started, he failed to appear on February 6th, which does not bode well for Mr. Lewis today. If the prosecutor is amenable, and their indication was that the prosecutor is amenable, we will issue, so the defendant failed to appear. For the competency review. Report is done. Report is done in the matter. Fairly strong allegations concerning this matter, but I will issue a bench. So Mr. Lewis is not here based on representations of counsel. He is not in the Zoom courtroom or the physical courtroom, and I will issue a bench warrant with a 48-hour hold at the request of the prosecutor. So, Mr. Milks, if you're able to get, you know the drill.
Appreciate it.
If you're able to get hold of Mr. Lewis, I am understanding Mr. Lewis does have some infirmities, but he's only a year older than me. So
I realized my stupid.
He's not that old, at least not to the court. But he does have some infirmities. I'll issue a bench warrant with a 48-hour hold. Anything else for the record in docket 2403-240 or 25-00159? Mrs. L.
Not for the people.
Mr. Milks.
No, Your Honor. Thank you for the court, and thank you to the prosecutor.
All right. So, Ms. Azell, where did you want to go to now? Or what case? Oh, let me grab this back from you.
I think I may have heard a whisper that we might want to go on DeAndre Holmes.
All right.
We had next.
I am an older gentleman, though, Your Honor. Give me a minute to get to the.
All right. It makes two of us, Mr. Abbott.
Oh, Jesus.
Mr. Milks is getting thrown under the bus by his colleague.
Well, that's all right.
Standard offers policy.
Standard operating procedure. All right, this is. What case is this?
This is
DeAndre Holmes.
Holmes. All right. And you're standing with Mr. Etheridge, Mr. Abbott?
I am temporarily.
All right, so we're on the record in docket 25-01643. That is People of the State of Michigan versus DeAndre Holmes. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office representing Mr. Holmes. He is standing to my right.
And sir, you are DeAndre Dean Holmes, is that correct? Yes, sir. Thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, I'm going to have to defer to Mr. Abbott on that.
Mr. Abbott.
Thank you. I've had an opportunity to speak with Mr. Holmes. He's expressed dissatisfaction with my representation. He's not confident I can adequately represent his rights. He has a good working relationship with Derek Etheridge, and he's asked that this case be continued until Derek gets back in the office.
All right, so we'll leave this on for preliminary examination. Is that a fair statement, Mrs. L?
It is, Your Honor.
Because we'll leave on for prelim. We reset this. We waived the 21-day rule. We reset for PCC today. So we'll do a prelim. We make sure that we have enough time to subpoena witnesses and such.
July 10th at 9:30.
July 10th at 9:30, and that's enough time, Mrs. L, to subpoena any witnesses you might need.
That would be, Your Honor.
All right, we've left it on. Mr. Etheridge will be back, and we'll be in representation. We still left it on for July 10th at 9:30. That would be a Thursday at 9:30. in July. Anything else for the record in 25-01643, Mrs. L?
Not for the people.
Mr. Abbott?
Nothing from the defense. Thank
All
you.
right, Mr. Holmes, we'll see you on that date. Thank you for your presentation.
Your Honor, have you called Antonio Anderson? I'm sorry to interrupt.
Anderson. I have not.
Okay.
Mr. Anderson is incarcerated, so he should be on Polycom. He's not, so he'll be brought up.
He's just not here, Judge.
Oh, he's not here, period. He's out of custody.
Yes.
All right.
Okay, my information, I thought he was lodged in Clinton County. I could have out-of-date information, Your Honor.
Okay.
Doing my best.
Let's see if we can track him down. Mrs. L, the prosecutor, said he may be in Clinton County.
It is my understanding that the Honorable Judge Stevens put him in custody in Eaton County. Oh, it
Okay.
looks like there was a write-up for him today. So he should be downstairs.
All right, so he should be downstairs because we did writ him out. So Mr. Valdori, did you need to talk to Mr. Anderson?
I would need to talk to him, yes.
I don't know how to do that.
Yeah.
Since you're on Polycom, and he's going to be in person. He's going to be
I
writ out.
see
He's
that.
gonna-
Maybe I could drive down there. I thought he was going to be zooming in from Clinton County. That was the information that I had.
Yeah.
Clearly, that was wrong, but
Yeah, he was writ out, and the other thing, Clinton County doesn't Zoom with anybody.
Okay.
Is my understanding. Yeah, if you can drive down here before you can see Mr. Anderson and talk to him, this is just a PCC.
Right.
But you may have to spend some time with him.
okay. So he'll be there if I get there before noon. We'll be good to go.
If we're not before noon, possibly. I've got weddings at 1:30 and 2 this afternoon. So maybe by 1 o'clock.
You know what, Your Honor? I have one other option here. Maybe I could speak with him from the jail if he's able to call me. I'm just thinking of different options here.
Yeah. The other thing is, if this is just being left on, we may be able just to leave it on, and then you can come down and speak with Mr. Anderson yourself while he's here.
Well, yeah, I don't even have the police report yet. What's the date of the preliminary exam? If you're able to tell me that.
Let's see. Yeah, the date of the prelim. Well, this was adjourned for good cause. And then conflict counsel is appointed. So we have not set a prelim date yet.
Do you see when the 21 days is?
Yeah, it's because he was incarcerated, we had to writ him out. It was adjourned for good cause. He was arraigned. It's passed. Yeah, okay. It's passed. It was on June 13th. He was in Clinton County, so we writ him out for today's date.
Okay.
So you probably should come down and talk to him.
All right, I'll do that, Your Honor. But the expectation being that we'd go on record and before you as well, correct?
Before noon or around 1-ish.
Okay, I'll try to just get there as soon as I can. Thank you.
All right. Thank you.
All right.
All right, so we're on the record in docket 25-01148. This is a Judge Ward case. Appearances for, this is people of the state of Michigan versus Derek Mitchell. Will the parties please introduce themselves for the record? Ms. Kachukas.
Good morning, Your Honor. Cassidy Kachukas for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Mitchell, who's appearing over Polycom from the Ingham County Jail today.
And sir, you'll have to unmute. I don't think he can unmute. So let's get the jail to unmute you. Or you can push the button to unmute.
There's a button you can push to get.
Yeah. So sir, if you push a button to get the jail, they'll come and unmute you. Post 2, visit 7. We don't. I don't think we have.
I'm sorry, email the jail, not that they come quickly, but I got
Who's Amanda H?
Your Honor, she is an alleged victim in a case that we have.
All right.
And I could call post too quick.
Yeah, if you
Call them all the time.
Okay. If you have the number, please help us out.
Wow, look at special numbers. And I got a message from Ms. Schroeder saying that Mr. Lee will be handling her sentencing.
Oh, I think the email I got was, Mr. Lee is on call to help. So maybe it's in
Where do you run the gas on?
No, we can go to the gas station. Oh, okay.
They're on their way to unmute him right now.
Perfect. Thank you, Mr. Goodrich.
And just so the court's aware, this is going to be a misdemeanor plea. He has a sentencing date, on August 14th at 8:30 on another file with Judge Ward.
All right, and then, so I will indicate that if that's the date you're looking at for sentencing, August 14th.
Yeah, like I said, he already has a sentencing date
All
with
right.
her.
And then he's willing to waive the plea to this court and be sentenced by Judge Ward?
Yes.
Okay. Just wait.
They're still muted, right?
Yes, they're still muted.
Yeah, he's asking if he fixed it. And the answer's no.
Getting good at real pretty.
And then, Mr. Lee, are you covering some sentencing for Ms. Schroeder?
Yes, Your Honor, if we have anybody present.
All right. We've got a few. I love technology.
Yeah.
Playback, we're still waiting to get unmuted.
There was a lot of background noise during that.
Oh, yeah.
And I had to mute them.
Here's the problem is that I don't know if they know how to unmute themselves.
Usually if I give them a prompt.
There you go.
Can you hear us now?
All right. Yes, we can hear you. Perfect, thank you. All right, and sir, you are Derek Mitchell, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Mitchell?
Yeah, I can hear you.
All right, thank you. This is the time set for a preliminary exam, probable cause conference. Ms. Kachuka, how are we proceeding?
Yes, Your Honor, it's my understanding that the defendant intends to plead guilty to an amended count of attempt fleeing in fourth degree. And obviously that would get rid of the habitual offender notice.
Okay, so it's an added
Added count too, I suppose.
Added count two. I know everybody does this different. Attempt, is it the attempt charge? Attempt
Yes, Your
fourth
Honor.
degree?
Yes.
And with successful plea and sentencing, count one is to be dismissed. Upon plea and sentence, count two. That is 750.479A1A. So it's the same code, but with an A after it.
Yes.
And that is 1 year and or $1,000.
That is my understanding.
Mr. Goodrich, is that your understanding of the offer is a plea to the added count to the attempt flee and elude in the fourth degree, a 1 year and or $1,000 with a successful plea and sentence, count one is to be dismissed.
That is correct, Your Honor.
May I inquire of Mr. Mitchell of his misdemeanor advice of rights?
Yes, Your Honor.
All right. Mr. Mitchell, you have the following rights, and I'm going to walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you, to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. You are represented today by Attorney Luke Goodrich. For purposes of this plea, you understand that you would have the opportunity for Mr. Goodrich to contest any charges brought against you or to cross-examine any witnesses at jury trial on your behalf. Do you understand that, sir?
Yes, sir.
Okay. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we placed on the record, but threats that it was not your choice to plead guilty. We'd also be giving up the right to appeal anything from trial, since you will be pleading to the attempt flee and elude misdemeanor instead. Is it still your wish today to waive your jury trial rights and plead guilty to the attempt, flee, and elude?
Yes, sir.
All right, thank you. I'm going to raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
You understand that if you plead in front of myself, Judge Ward would be the person who's sentencing you, and we've already gotten that date. Do you understand that, sir?
Yes, sir.
And you're in line with that also, Mr. Goodrich?
Yes, Your Honor.
All right, I'm going to bring your attention back to October 15th, 2024, at the offense location of Martin Luther King, I-96 in the city of Lansing. Were you operating a motor vehicle at the time on Martin Luther King on I-96 on October 15th, 2024?
Yes, sir.
All right. And at the time, were you given a visual or audible signal to pull over the vehicle by a Michigan State Trooper?
Yes, sir.
And you knew they were a Michigan State Trooper at the time that they asked you to pull over, and you did not follow the direction. Is that correct?
Yes, sir.
All right. Anything towards a factual basis, Ms. Kachukas?
Not for the people, Your Honor.
Mr. Goodrich?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. And we will set this for, so we'll refer to probation, first of all, obviously. So probation will be out to see you concerning the report that's being done for Judge Ward, and we'll set for sentencing in front of Judge Ward. On August 14th. What time?
August 14th at 8:30.
At 8:30. All right, we'll set in front of Judge Ward for August 14th at 8:30 to coincide with the sentencing on another matter. Anything else for the record in 25-01148, Ms. Kachukas?
Not for the people, Your Honor.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, Mr. Mitchell, you all set? Judge Ward, we'll see you on August 14th at 8:30.
Oh, Your Honor, I'm sorry. There was one more thing. Mr. Mitchell did ask me to want to address with the court. He was currently received a 2,000 cash or surety bond on this file. That now that the matter is no longer a felony and is now a misdemeanor, if the court would consider reducing it to 2,010% perhaps. I know he did fail to appear in the previous case, which is why these are aligned as they are.
Right. All right, Ms. Kachukas.
The people will defer to the court in this matter.
The court knows nothing about this file. I know less than you do.
On this file, I mean,
I would point out that this case actually predates the other case. I don't know how exactly that worked out, but it's
that's about all.
There's a fail to appear with on Judge Ward's other file. I think it's a fair request to set it at 10% since the defendant has pled to a misdemeanor as opposed to the 2-year. That's been cut in half. So I will set it at 2,010%.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
All right. So you're all set, Mr. Mitchell. Thank you for your appearance today. Thank you, Mr. Goodrich.
Okay, thank you.
Thank you.
And Mrs. Zell, where are we heading next?
If we could go ahead and do the sentencing for Chancerio Flowers.
Chancerio Flowers. All right, so we're on the record in docket 24-03537. That is People of the State of Michigan versus Chancerio Flowers. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Flowers. Mr. Flowers is present and staying to my right at this time.
And sir, you are Chancerio Flowers, is that correct?
Yes.
Thank you. This is a time set for a sentencing in the matter. Mr. Milks, have you had the first of all, is there any restitution on this matter, Mrs. L?
There is no restitution,
All
Your
right.
Honor.
Mr. Milks, have you had the opportunity to go through the pre-sentence report with your client?
We have had that opportunity, Your Honor. There are a few just very minor, one minor correction, another correction.
Okay.
First and foremost, Your Honor, the, actually, this might be correct. I lied, just one correction, Your Honor. The, regarding his custody, in-time custody, it reports that he has 19 days, and that was dated up until 5/29/2025. The full amount of time that he's been in at this point, Your Honor, I've got is 46 days. He's got the first day he was arrested in 12/3, and then 5/12/2025 up until today's date, 6/27/2025. I've got 46 days.
And the 19 days was of what, as of what date?
The 19 days was from 5/12/2025 up to the date of, I believe, the interview. Don't quote me on that. Up until 5/29. I'm sorry. So it was, there's the day his arraignment date, which was 12/3/2024. That's day one. And then he was arrested on 5/12/2025 through 5/29/2025. That's the 19 days he originally had.
All right.
And the total amount, 46, goes from 5/30 up till today's date.
Oh, from May 30th to today's date.
Yes, Your Honor, since 5/19 was already counted in the 19 days.
All right. And so the May 30th date is still on this file. Does Mr. Flowers have any other files out there? I just want to make sure that it's all on this file.
No, Your Honor, no, this should wrap up everything he's got here. He does have a holdout in Clinton County. He's going to have to take care of this.
So you have a total of 46 days. What does the computer show?
Well, 5/29 is in $3,000 cash, $3,000 1% bond. So if we PR in 7 days after that, that's why I'm kind of confused. It's such a misdemeanor, so they hold them for 7 at best.
An indication of this. All right.
This
So
doesn't make a lot of sense,
okay.
the way that it is in the computer right now.
All right. So right now, based on the allegation, you were, Mr. Flowers, you were not PR'd after the May 30th date after 7 days. You've been in the entire time.
I've been in.
Okay. Based on that representation, we'll indicate that there's a total of 46 days previously served. And any other corrections to Mr. Mills?
No, Your Honor, that should be it.
All right. Allocution, Mr. Milks, and then we'll go to Mrs. L and then to Mr. Flowers.
Thank you very much, Your Honor. Your Honor, I'm asking that the court adopt this recommendation. I think it's very important that throughout my representation of Mr. Flowers, especially from his arrest on 5/12, Your Honor, I should say, his main focus here has been to get treatment. He's asked for, he has a serious and significant problem, which is reflected in the PSI regarding methamphetamine and stimulants here, Your Honor. This drive that he has is something that is real, is something that he put forth with the investigator in this matter. So we are asking not only that the court allow him for the opportunity to do some intensive outpatient programming, Your Honor, but if the court could also consider something about having my client enroll in RISE. I think that's something that would be truly beneficial to him instead of just kind of putting him out there on the street, giving him that extra help to really secure long-term and meaningful sobriety in this matter, Your Honor. My client also, my client's issues here stem largely, Your Honor, from the trauma that he suffered when he was younger regarding his father's passing. And it's not something that he's been able to at least appropriately deal with, Your Honor. Sobriety, with proper care, proper treatment, I think is something that he can address all of these issues together with, Your Honor. So I'd ask the court to adopt the recommendations as set forth. And again, I would just let the court know that he does have to go to Clinton County after this, Your Honor, to address something he's got out there as well.
All right, thank you. Mrs. L, any comment on this file?
No, Your Honor, we'd leave this to your discretion. Thank you.
All right, Mr. Flowers, is there anything you'd like to say to the court before the court passes sentence?
Yes, I just want to go to treatment and continue, finish treatment, go through with the whole process of treatment and continue working and just be around people that love me and don't want to see me in here just like I don't want to be in this type of predicament ever again. That's it.
All right. So this is for a guilty plea for December 20th, 2024. On use of methamphetamine. The defendant is to spend 180 days in jail, credits given for 46 days previously served, and then we'll suspend the remaining amount 134 days upon successful completion of probation. So no upfront jail on the matter. This is on a state case. Your probation officer is Nathaniel Nice, all right? And he's going to start with outpatient. I'm going to place on here under other that rise should be considered. I think that's a fair statement. The 8 months probation, I'm going to adopt the recommendation, all right? The next 8 months, it's really we have to be in a place to meet you where you are. And it sounds like you're reaching out for help now, okay? And we have to be prepared and use all our resources that are available to help you in that endeavor. Because Mr. Flowers, as I've said before, I'm not concerned about Mr. Flowers for the next 8 months. I know where you're going to be. You're going to be on probation to me. I'm more concerned about Mr. Flowers in the next 2 or 3 years, where you've got to make decisions that not only going to affect you, yourself, your loved ones, people who care about you. You know the drill, right? It is extremely hard work. It is extremely hard work, but with vigilance, it can be taken care of. Okay, it never ends. Okay, doesn't end today. Doesn't in 20 years from now. Doesn't in 40 years from now. And we're all affected whether we like it or not. Okay, with that understanding, I'm going to set fines and costs: $200 fines, $200 costs. Crime victims' rights fee of $75, state minimum cost fee of $50, and I'm going to place you on probation for 8 months. So that's 240 plus 125 plus 400. That's a grand total of, I know that's not right. Plus 125 plus 240. All right, 765. That can be placed. That can be paid over the course of probation. I'm going to place you on probation for 8 months. You'll be reporting to Nathaniel Neves, okay? No assault or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs, enter your analysis as directed, and pay fees. That's usually where people mess up, okay? That's usually where they don't drop or they drop dirty, and then they come to me and they're indicating they need help, right? And then we've got to figure it out. We've got to let resources go. You know, we have to put resources in action. You're indicating this should be a part of that, and I know that to be true. Okay, so this is your chance to show off. Okay, it is going to be extremely difficult, but I have faith in Transario Flowers. All right, no bars or nightclubs. Outpatient substance abuse as a start. And then we'll see if RISE is available. Usually that's the problem, is the resources is whether RISE is available. I will put that in other. Okay, so submit to random PBTs, enter your analysis as directed by Nathaniel Neves. No bars or nightclubs. Outpatient substance abuse as a starter. Obtain, maintain employment if you're able to. No purchase or possess firearms, ammunitions, or weapons of any kind. And then we'll see if RISE becomes available through the resources. Do you have any questions of me, Mr. Flowers? You should go clear up whatever you have in Clinton County, so that's not hanging over your head. And then as long as you do what Nathaniel Neves asks, you should be in good stead. Okay, sir?
Okay.
All right. So that's all on 27, on June, that I'm gonna sign this judgment of sentence for June 27th, 2025, and you should be all set. Thank you, sir.
Thank you, Your Honor.
I don't know if we have to make that. To rise availability. So.
It looks okay.
Okay. That can be your call.
If they really can't read it, I have this ready to go. So
We'll-
I'll always print it. and have
We'll
you sign
know.
it.
Yeah, we'll know.
I can always just.
All right, who's next, Mrs. Zell?
So I believe we can move on to the sentencings, but I think we may just need a second there.
All right.
And then on Ward's docket, it sounds like.
We have one matter left on Judge Ward's docket, but we need Ms. Wazzy for it.
All
I
right.
have two.
One.
All right, we have, so does Eureka Nicholson have an attorney?
She does not, Your Honor, that
I
I know
thought it
of.
was a rate.
Was hoping for some clarity on the record, I guess.
All right. Is Miss Nicholson here?
Yes, Your Honor, I believe.
All right, let's go ahead and call that case. And we'll see if we can.
I just want to know if I should bring him up or not.
I'm sorry. Hold on one second.
All right, so we're on the record in docket 25-01420.
Eureka.
Is that, yeah, that is People of the State of Michigan versus Eureka Nicholson. Ma'am, you can come up here. This is set for PCC today. Mr. Brigsia, your presence for the record.
Yes, Your Honor, thank you. Maluda Buxia, Assistant Ingham County Prosecutor on behalf of the people.
All right, and ma'am, you are Eureka Nicholson, is that correct? All right, thank you. And you are not represented by counsel today, is that correct?
No, I'm not.
All right, have you made application to the Public Defender's Office in this?
I was denied, but I talked to my niece's lawyer today and she said that I can appeal, so I'll do that.
Okay.
As well as reached out to an attorney myself, but have financial issues.
All right, so you plan to go back and make reapplication to the
Yes.
defense attorney because your financial status may have changed.
Yes.
All right. See to reappoint. But you do want to be represented by counsel, is that
Yes.
correct? All right. You understand that if this falls through the public defender, you'd be responsible for retaining your own counsel.
Yes.
Okay. This is a PCC. Mr. Buxia, do you have any objection to me just leaving it on for the prelim? And then we'll go from there. I don't want Ms. Nicholson to waive any of her rights while she doesn't have a lawyer.
Correct, Your Honor. I think there have been some good cause waivers already because of the timeline of this case.
Right. So and so I will reflect that that on May 22nd, it appears that counsel was sought and it was left on for prelim. And then on May 29th, that was the determination that you were not eligible for the public defender's office. So good causes have been set in this matter. So it was adjourned to this date for Court of Appeal for this. I would assume that we're past the 21-day because of good cause adjournments. This would be another good cause adjournment for the following week.
Correct, Your Honor. And I don't think Miss Eureka Nicholson, she prior and times prior appeared by Zoom. So I don't think anybody ever talked to her about the appeals process through the defender's office. However, I will, and the people have no, we hope to leave it on for a preliminary examination next week. What we would be asking though, Your Honor, is I guess to do so without witnesses.
Yeah.
However, that then implicates Miss Ariana Nicholson, who I believe Miss Eureka Nicholson spoke with Ariana's defense attorney. That's the defense attorney that she's talking to, Your Honor. So I have no problem proceeding in that fashion, but it is a co-defendant case, and so we don't want to bifurcate any preliminary examinations. I'm sure Miss Wanji doesn't have a problem with leaving it on next week without witnesses. However, we haven't had that conversation, so I wouldn't be able to.
All right,
accurately-
It's not set for next week. It's actually.
Oh, it's set for the 10th,
July
okay.
10th.
Okay. Okay, so it's left on for July 10th. I find good cause to adjourn to July 10th because Ms. Nicholson does not have appointed counsel or retained counsel. Ms. Nicholson, if you don't have the public, do you have the public defender's number?
I do.
Okay. You need to call them and set it as a priority to get representation on that date, okay? If that doesn't work out because of whatever financial application, you need a plan B quickly, okay? Because you've got to get representation for the July 10th date. And that would require, you just need somebody, because they're going to need discovery, they're going to need all kinds of material, but you're just running out of time, okay? You're running out of time. I find good cause to adjourn to July 10th. This is a co-defendant case. The co-defendant is Ariana Nicholson. And then we'll address that issue with Ms. Wanji, who is the public defender assigned to that case. And then if Ms. Wanji is, then I think the public defender would probably be seeking conflict counsel.
Exactly right, Your Honor.
So that might take some time, but you can address that on July 10th, all right? All right, do you have any questions of me, Ms. Nicholson? I found good cause to adjourn this to the actual prelim. We'll set it for prelim on that. I don't know if that's,
It's already been set.
okay, for July 10th, 2025. You should have either conflict counsel, retained counsel at that date to start receiving discovery on your behalf. Mr. Boots.
Just for clarity, Your Honor, as regards to Miss Eureka Nicholson, would that preliminary examination be without witnesses at this time?
That would be at this time, I'm going to indicate that it's without witnesses,
okay,
just to get somebody on board.
Yes,
if I was going to say that if I was going to put it that there would be witnesses, I'm really putting in a position that everybody's ready to go and you don't have a lawyer. And then we're just going. And I don't know how Judge Ward runs her courtroom, but I do know that if your witnesses are here, we're just going to go. Okay. So there's some room with the prosecutor not having any witnesses, but you should start thinking, I put this on a high priority to be represented by July 10th. All right, ma'am?
Yes.
All right. Anything else for the record in 2501420, Mr. Buxia?
no, thank you, Your Honor.
All right, Ms. Nicholson, do you have any questions of me?
July 10th, that'll be in person.
July 10th would be in person, and I should give them a time.
July 10th at 9 o'clock.
July 10th at 9 o'clock, and that'll be live in person.
Thank you, different courtroom.
Yeah, it'll be right across it'll be in Judge Ward's courtroom, which is right across courtroom number 1.
Okay.
Mr. Brucey, if you could give her that notice.
Yes, I can.
Please.
Yes, thank you.
Thank you.
Yeah, we're just waiting for this one.
All right, we'll await Ms. Wanji's presence. Where did you want to proceed next?
I think we can move forward on the sentencing that we have set.
Do you want to just go in order?
Yeah, I think so.
So Christopher Jackson.
We already did that one.
Oh, I'm getting behind.
It's okay. I think Zachary Kelly is the first one that is left for sentencing.
All right, Zachary Kelly. I have Mr. Austin too. Tony Austin.
Yes.
All
And
right.
that I have Micah Shabazz as well, and then Lewis Moshi.
All right. All right, let's go on Zachary Kelly.
I do not believe he is here, so that I believe will be a failure.
Okay. All right, let Mr. Lee check and we'll call that.
While he checks, we have a probation violation hearing set today for Zarek Daniels. We did not receive any probation violation information for that. I'm not sure if they were arraigned on that because he failed to appear for the arraignment and is now in custody.
All right, let's take a look at that file after we do Mr. Lee's case.
Okay.
Because, yeah, I don't see Mr. Freeman here, but this is probation violation. So I don't know if he'd be, anyway.
But are you talking about the Daniels case?
Yes.
Georgia Need was assigned to the probation violation. He called me and advised me that he has not had contact with the defendant yet, but he has not received any discovery yet.
All right.
So
That might, then everybody might agree that we do that some other time. Yeah, okay. All right, because it appears that there's been some discovery issues that have not been. All right, so we're on the record in docket. This is 25-01066. That is people of the state of Michigan versus Zachary Kelly. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Zachary Kelly.
All right, this is the time set for a sentencing in the matter. It was set for 9 o'clock. It is now 11:25. I do not see Mr. Kelly in the Zoom courtroom or the physical courtroom. Mr. Lee, have you had any contact with Mr. Kelly?
I have not, Your Honor.
Based on the representations of counsel, I'm getting indication that Mr. Kelly has failed to appear for the sentencing. And Ms. Ezell, how did you want to proceed?
Your Honor, at this time, the people would request a bench warrant be issued.
Any comment, Mr. Lee?
No comment.
All right, so we'll issue a bench warrant for fail to appear. Anything else for the record in 25-01066, Mrs. L?
Not for the people.
Mr. Lee?
No, thank you, Your Honor.
We should be all set on that file. And then let's go on Mr. Daniels. This is probation. I don't think Mr. Kelly's ever been arraigned on these.
Well, he was.
On June 16th?
Yes.
Yeah, I have him arraigned. So he has been arraigned on the pretrial in front of Magistrate Milmore on June
Probation
16th.
violation. It looks like Nathaniel set the date. He's supposed to be in custody at 5,000 cash shooting. It says no PR for 14 days. Let's figure that one out.
So is Mr. Daniels in custody?
Do not know.
Mr. Daniels is in the courtroom right now.
Mr. Daniels is in the courtroom?
Okay.
All right.
I thought you guys were talking about Kelly. You said Kelly.
No,
I
we
would have
switched
said something
files.
sooner.
We switched
And then-
files.
Well, Judge said Kelly. I thought he was still talking about Kelly.
We were talking about Kelly. So we'll let Mr. Lee, this is Mr. Kelly. We'll let Mr. Lee's talking to Mr. Daniels.
So this was back.
What's that?
Is there a pink sheet in the probation file?
At that time, we were serving time in Livingston County Jail. So your
I'll give
probation.
you a call. I don't see one.
It's right here.
So there's been
Pink sheet's
a
not pink?
probation.
Oh.
I don't know.
Oh, the pink sheet.
Can you just make a copy of this for them? Yeah, I don't see when Nathaniel actually emailed it.
That's the problem. So what we're gonna do is go back to the
Ms. Wanji, were you ready to go on Ariana Nicholson?
Good thing I'm not doing this job. And give one to John and to, yeah. I only print one.
All right, so we're on the record in docket 25-01421. That is people of the state of Michigan versus Ariana Nicholson. Will the parties please introduce themselves for the record? Mr. Buxia.
Thank you, Your Honor. Maluda Buxia, Assistant Ingham County Prosecutor on behalf of the people.
Good morning, Your Honor. Melanie Elduwanji from Nicholson, who's appearing at the council here.
All right, and ma'am, you are Ariana Nicholson, is that correct? All right, thank you. This is time set for a probable cause conference. Mr. Buxia, how are we proceeding today?
Thank you, Your Honor. At this time, the preliminary examination appears to be set for July 10th. However, as previously noted in another case, this is a co-defendant case, Your Honor. And briefly speaking the matter over with Ms. Wanji, we'd be asking the court to leave this set for July 10th. However, with the understanding that it would be without witnesses.
All right.
And then on July 10th, obviously, we can go for a better preliminary examination date.
All right, so Ms. Wanji, you understand the nature of this. Ms. Nicholson is out, is out. This has been adjourned twice for good cause. There is some question concerning whether the co-defendant has to reapply to the public defender's office, and then conflict counsel also has to be appointed. Any objection to this being adjourned to July 10th without witnesses so that we could just see if Miss Nicholson, Eureka Nicholson, can be part of this file, and then go from there. So it'd be adjourned to July 10th, 2025. It would be a good cause adjournment.
Yes, Your Honor, I understand that, and I was explaining to my client that the court had already said that they were going to grant the request from the prosecutor to run the preliminary exam for judicial economy, both preliminary exam at the same time.
All right. So I will adjourn for good cause. So Ms. Nicholson, you're not waiving any of your rights. Okay, I'm adjourning for good cause to July 10th. I would consider, because the co-defendant in this matter doesn't have an attorney in a seat, well, even if she gets a public defender, they're going to have to go get conflict counsel because Ms. Wanji is presented with a conflict through that office. We'll set it for July 10th just to see where it lands, okay? Just to see what the status of it is. And for that reason, we don't expect to go that way. There'll be no witnesses called for that day, but that'll give us some inclination of where we stand in regards to the case. If once the witnesses are subpoenaed, I would expect this to go, okay? So that would be sometime after June 10th at the subsequent preliminary examination. Okay, good cause adjournment. That would be in front of Judge Ward for July 10th.
Thank you, Your Honor.
Do we have a time for that?
I believe it was.
I think it was 9 o'clock.
9 o'clock. All right, so you'll be in front of Judge Ward on July 10th at 9 o'clock. Thank you, ma'am.
Thank you, Your Honor.
Thank you.
If you want to just confirm, we just get further handout with the data. So I want to confirm that's the time. Thank you.
Did you want to go on Micah Shabazz?
I believe we can do that. Yep.
Okay, is that the next one?
Yeah. Yep.
All right. All right, so we're on the record in docket 25-00666. That is people of the state of Michigan versus Micah Shabazz. This is set for sentencing today. Appearances for the record, Mrs. Elms.
Thank you, Your Honor. Gabrielle Azal, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Jared Austin appearing on behalf of and in the absence of Mr. Shabazz, filling in for counsel of record, Mr. Palmer.
All right. This is the time set. It was set for 9 o'clock. It is now 11:34. It would appear the defendant has failed to appear. I do not see Mr. Shabazz on the Zoom courtroom or the physical courtroom. Have you had any contact, or has Mr. Palmer had any contact? I don't know who did you say you were covering for?
It's Mr. Palmer's file. He is currently on light duty. Ms. Schroeder was supposed to be
All right.
covering this, but she's tied up in other matters, so I'm covering for her. She's covering for Mr. Palmer.
All right.
But
And have you had any contact with Mr. Shabazz today?
I have not. The notes indicate that Mr. Palmer had been this week making attempts to contact Mr. Shabazz by phone, which has been unsuccessful. I have checked Vine Link. He doesn't appear to be in custody, and I believe, unless I'm mistaken, my review of the file indicated that he did not appear for the pre-sentence investigation.
All right, and I do not, that's true. As of May 19th, Mr. Shabazz was unable to be reached by the probation department.
And he also, upon reviewing the files, he may be in bench warrant status in another file.
Okay. Based on all that information, Mrs. L, how would you like to proceed?
Your Honor, at this time, the people would be asking for a bench warrant to be issued in this case.
All right. Any comment on that, Mr. Austin?
Your Honor, I would leave it at the court's discretion.
All right. For the failure to appear today for sentencing, and it looks like we didn't have a pre-sentence, so we couldn't go on May 19th either. There was a failure to appear on May 19th as he was released from jail. I'll issue a bench warrant on the matter for the fail to appear of defendant. Anything else for the record in docket 2500666? Mrs. L.
Not for the people.
Mr. Austin.
No, Your Honor, thank you.
Thank you. Go on. Tony Austin.
Yes, Your Honor, we are ready on that.
All right, so we're on the record. Mr. Austin's called my way.
Yep, just to
Just
double
in
check.
case. We have early PCs on Adams and Anderson also. Have we done those or?
Anderson is the one the attorney was driving from wherever he was.
And then Adams? Did we do that? I lost track. I don't have a
That
file.
was the one that we did yesterday because he was here for.
Yes.
That's right.
I
So
was
we
like-
get two efficient.
Like,
I was like, we did something with it, but I don't know where or when.
All right.
You can. That's
Motion,
This one?
and then the motion.
I'll let you sign wherever you want.
Then Ms. Osborne, you're here on the motion?
Yes.
All right, we're gonna call that as soon as we can. We're just trying to get through the rest of the criminal docket. So I'll call you as soon as we're able, all right, ma'am?
Okay, thank you.
Thank you. I think is this All right, Mr. Osborne, we can call your case of 2408-761. I think you understand the problem is I don't have a proof of service on the motion. Is that a fair statement?
Yes, I looked, Your Honor, and I did not see one either. I responded back to your clerk and asked her if the court just wanted to reschedule and I could file a proof, or how do you want to handle
Yeah,
it?
I think that would probably be a fair. You've also been so patient today, waiting your turn. But we had 2 dockets tonight. We almost got done on time, almost. I'm going to adjourn the motion. And we'll give you some time to perfect service on the motion. And about how much time do you think you'll need, Ms. Osborne?
I'll get it out today, so I mean, really just if you could reschedule it for a week, or it'll probably be a little bit more than a week given
So
the holiday.
any time, yeah, any 2 weeks to 4 weeks.
2 weeks preferably, Your Honor.
All right. I think we have July 15th at 2:30.
Oh, hold on one second.
All right, so we'll set the motion for July 15th at 2:30.
One
and
second,
then we'll
Your
see
Honor. I
if-
think I just need to check my schedule real quick, and my computer is just
All right.
not moving as fast as I would like. July 15th. Okay, yeah, if it's at I have a hearing at 3 that's via Zoom too. Is there any way?
We can put it at 2.
Yeah, that would be perfect.
All right. So let's set July 15th at 2 o'clock. Yeah. And then we can perfect more sentences. That's shocking to me. We can perfect service on July 15th at 2 o'clock.
Okay, thank you, Your Honor.
All right, thank you, Ms. Osborne. We are drowning in sentences. How many do we have for that day?
3.
That's not too many. That's 4 less than we had today.
Fair.
Somebody's playing a body cam.
Yeah, all the dockets are good. Well, the 2 of us that are here, we had big dockets, or bigger dockets.
All right. So the first one is Amelia and Austin at 1:30, and then the wedding at 2.
So if you want to get back like 1:45 by the time we get out of the paperwork together.
Yeah, if they're here early, let's get them done.
Okay,
Because
you want me to send you a message if they get here early?
I'll probably be here like at 1:15 for the 1:30.
Okay.
And then we have the 2 o'clock. But yeah, we moved a lot of cases.
We did, we actually got rid, I mean, we did just kick them down